Evening, everyone. All right, so they would, excuse me. All right, so good evening. I'm Keith Ainsworth. I have a law practice in New Haven, law offices of Keith Ainsworth. I practice by myself, and it's distinctly my privilege to be here. I mean, one of my favorite client groups is land trusts, and I've had the enjoyment of working with the East Granby Land Trust for a few years now, and happy to help out. So I've got a slideshow that I'm going to put on. And when I do that, just because I'm not very good at PowerPoints, that's not the world I live in, it's going to fill up my entire screen. I won't be able to see any of you or the chat or anything that's going on other than my screen, which will be a little weird because it'll be looking like I'm talking to my own screen from my perspective. However, I do these things with slides, but that doesn't preclude the fact that if you have a question, we're really here to answer those, because my presentation is based on sort of my encroachment presentation that I've done, and I've modified it over the years. In fact, this one's unique, but my generic talk is maybe not what you might want to hear. There might be other questions. So feel free to interrupt and ask questions during the middle of this, because it's really about what you want to know. With that said, and you'll have to forgive me, I'm getting over pneumonia, and I'm sort of the tail end of that. So if I wheeze a bit, you'll know why. All right, so my background is I'm an environmental, what I bill myself as a private environmental enforcement attorney. I've been doing environmental litigation for about 34 years. I'm currently the acting chair of the Council on Environmental Quality, which does a number of functions, one of which is to accept complaints about violations of environmental law and refer them out to the right agency, or to get the DEP to sort of hold hearings on that. We also review state agency actions that might have environmental impact, and we review citing council matters and a few other things. So I have a sort of broad background in environmental policy as well as law. Tonight, I'm going to try to stay away from too detailed a talk about law. I want to talk about process, because really what encroachments and managing things from your perspective are, I mean, you're not going to pretend to be lawyers. You're not going to try. It's not really a role. And frankly, a very small fraction of encroachments end up with a lawyer. Most of it is you managing those issues. And so I hope to be able to give you some pointers and some ideas about how you can do that. So I'm going to share my screen and disappear off of the earth here. Let's see. Okay, and let's see, I've got okay, you can probably see my slideshow. Oh, that's interesting. Here we go. Okay. So this is actually a talk I do from the CLCC conference, and it's a branch of the Land Trust Law School. It's something I made up, which is basically it's a lawyer talk to land trusts on various issues that might be of interest to them. And you might, if you went to the CLCC conference this year, will recognize a couple of the slides, although the content is very different. This is customized just for you guys. This first slide is actually, and several of the other slides are all generated by artificial intelligence. So I asked the artificial intelligence to come up with a scene of a woodland encroachment, and this is actually what it came up with. And it's actually quite accurate in a lot of ways. You've got the stumps, you've got the random slash and trunks thrown aside, and you've got the tracks through the woods, probably a wetland, because I think I see ferns in there. This is a classic encroachment. Now, I don't know how many of your lands, even remotely resemble this, but this is not all that unfamiliar to me. I thought that it was eerie that the AI came that close to accurate. But there you go. So this is about managing and resolving trespasses of conserved land. And what I mean by that is the first layer of defense is to manage the issue. And the last resort, of course, is going to court. So there's a difference between conservation easements and fee properties for the purposes of managing them. By the way, the slide on this one was what the AI envisioned being an impressionist painting of an encroachment. So let's talk a little bit about easements and fee ownership. So easements You may have some easements under your care, and you may have fee ownership. And fee ownership, I'll define it right now, which is just title. You own the land outright, like a deed, just as if you own your own home and your own land. Easements are where you own the or the restriction on the property that prevents it from being developed or has restrictions from being overdeveloped. Easements can vary from A to Z. In other words, they are custom built and custom designed, and there's actually a model easement at the CLCC website, which was worked on by some of my colleagues, and I did not myself, but I know many of the people who worked on it. And it's a model easement that provides for how you can preserve land and have all of the options available to you to customize it for your particular purpose, which is whether it's forever wild, whether it's a farming easement or an agricultural easement where you can have active farming, but conserve it from active development or being put into, a subdivision. And so there's a lot of different ways you can do an easement, and the model easement is there on the CLC website where you can obtain that. And I put a reference here to 47-42A, which is the Connecticut General Statutes, that says that easements are enforceable by the Attorney General. They're also enforceable by the party who holds them. In other words, you would hold an easement and some other person, either the person who granted you the easement or another owner down the line, owns the land underneath. They're usually living there or actively working the land. And so you now have a partner in that arrangement. They're a little more they're easier to obtain than fee ownership because you have to pay less for them, and you can often get grants to get easements. But fee ownership is usually more expensive per acre. But easements are more difficult to manage because they're often very strict increased monitoring duties. And there's also the fact that somebody else is on the land doing things and they have reserved rights to do things. Whereas land that you own, you control, and usually you reserve it for just hiking or passive recreation. And so there may be a few trails, but your duties with regard to the land you own in fee are really just monitoring. Whereas with easements, you really have to monitor them every single year. And whereas perhaps with a fee ownership, you can get away with something like a year and a half, but I wouldn't go more than 2 years. And I'll explain why maybe a little later in more detail, but it has to do with the statute of limitations. If you miss an encroachment for 2 years, one, it'll be hard to get the proof together because a lot of things will be changed by then. And then number two, the person may be gone. A lot of your evidence may be gone. And also some causes of action that you can file in court to help you enforce your rights may also have disappeared after 2 years. Not all of them. And if the activity is still going on, that's called a continuing tort. And that's 2 year statute of limitations can extend out indefinitely if they're continuing to cut. But if they just cut and run, the day they run is the day that 2 years starts to tick. So you do want to inspect your properties at least a year, year and a half, no more than a year and 3/4, because if you decide that there's something that needs to be enforced, you need to get that to your lawyer, and you need to give them enough time to prepare to do something. And it's got to be more than a couple of weeks. I, in fact, had a $2 million calculated encroachment that I couldn't do anything about because it came to me too late. Now, the land trust in that case could be forgiven because the inspection happened just before the pandemic, and they thought they had time, and then the entire world shut down in March after that November inspection, and so they didn't get around to it until 2 years later. So that's the two different types of land. Now, the statutory tools, I've got a little toolbox here that the AI thought was a box of statutory tools. It's a little freaky if you look at it close. So the park replacement statute is, I'm going to go through a couple of statutes that are kind of signature ones. The park replacement statute is kind of a personal pet project of mine. It's a statute that's not known much about, but it's and it's often breached just because people don't know about it. But it basically says if a municipality takes a park that they have, and they try to do something that's non-park with it, or open space, if they have municipal open space, and they try to do something else with it, they have to provide replacement land of the same size and value and give a notice in public hearing. They have to actually hold two public hearings, or no, provide two notices and hold a public hearing. And it's really quite powerful because if they take open space that was dedicated as open space, you can make them replace it. Now, in the towns that, well, other than West Hartford, you probably actually have a dearth of parks. You have probably fewer parks than your other cohorts within the Trap Rock Conservancy. But in more rural towns, towns may hold an awful lot of open space. And so the statute is very important. There are a couple of cases that came out where judges said it only applies in cases of eminent domain, which doesn't make any sense because municipalities don't use eminent domain on open space, really. But so right now there's a bill pending in the legislature, passed the Senate, and is being considered at the House. May have even passed today, I don't know, to fix that. And but that's one statute you should know about. If you take a park, you have to replace a park. The Connecticut Environmental Protection Act. This is the catch-all statute that allows for you to file an action to seek an injunction to restore a property, and it carries with it attorney's fees and costs. And it's just a straight up, if there's unreasonable harm to the environment, you can file an action no matter where you are in the state. You can file it on an action anywhere else in the state. And it basically is what we call a private attorney general's act. It imbues everybody with the right to trigger that. That's one of the causes of action that land trusts use. The Inland Wetlands and Watercourses Act is similarly powerful. It also has attorney's fees and costs. Plus, it also has up to $1,000 a day fines. Now, the court has up to $1,000 a day, which means that could be $0, it could be $100, it could be $5, it could be $1,000. But it's a very powerful statute that allows for you to get an injunction if someone has encroached on wetlands. Now, there's a very famous case going on right now with the governor who shall remain nameless, who actually committed a trespass on wetlands, and I assume the enforcement by the attorneys in that case are using the Inland Wetlands and Watercourses Act, if not just the Wetlands Agency itself. But and then this last one is an anti-SLAPP suit, and basically what it says is if someone tries to, actually let me back up. A lot of land trusts get really nervous about taking action or speaking out at public hearings or at public meetings about environmental harms that they might see to their properties or anything, because they feel that they might garner some legal liability, that someone might try to sue them for speaking out and saying the wrong thing. Well, this anti-SLAPP suit statute at the bottom of the screen here actually is meant to stop that from happening, because that was what was known as a SLAPP suit, a strategic lawsuit against public participation, SLAPP. And what would happen is someone who was a developer or an encroacher heard you speaking out against them. They would sue you for either interference with a business relationship or a contract, or they would sue you for defamation, and they would try to scare people, even though it was frivolous, because people are like, oh my gosh, I don't want to have to defend that. I don't have to hire an attorney. Well, this suit, this anti-SLAPP suit provision actually allows you to dismiss that within 30 days and get all your attorney's fees and costs back. So it's a real deterrent from pulling that maneuver. Then not only are there statutory tools you can use, but there's common law tools. In which, even before the statutes were passed, under the black letter law that goes back to medieval England, there's negligence. And I often allege negligence in a complaint because there's homeowners insurance for an encroacher. If you've got a neighbor who's encroached on one of your properties and they've cut down your trees or something, and they went over the boundary, whether it was a mistake or whether it was maybe an intentional mistake, you can allege that they did it negligently, and their homeowners insurance will cover that. I've had a number of cases where I've gotten the insurance company not only to defend the case, but they paid, because the insurance defense attorneys are really highly unfamiliar with encroachment law and encroachments and how to value them. And if you talk to some of my clients, the other land trusts, I've got gotten multi-$100,000 settlements. Just recently, I got a judgment about, I think it was last week, for $300,000 for having cut down 81 mountain laurels on land trust property. We'll talk a little bit more about how we got to that number. The number was actually 608,000 for a base value, and with multiple damages, it would have been about 1.8 million. Then there's also trespass. Look, if someone crosses the border onto your property, just like the property that you own at home, your house, if your neighbor comes onto your property without your permission, I mean, obviously, if they're just coming over to have tea and crumpets, that's not a trespass. But if they come across onto your property without your permission, that's technically a trespass. If they come over your property, cut down your trees, same thing. Same thing with land trusts. Land trusts are really no different than any other property owner in the basic sense. You own the land, you have a right to defend the land. And in fact, as a land trust, as a nonprofit to whom people can donate money and land and get tax deductions, the assumption is that you actually have a duty to protect those properties. Otherwise, you technically could be decertified by the IRS. Very rare for that to happen. You really have to abuse the privilege pretty hard. But I'm just saying that because it's a duty that you have, and it's a responsibility. Land trusts don't just sort of vacuum up parcels of land and just put them on the shelf and forget about them. You actually should be stewarding them and making sure that they're kept intact over time, which is where encroachments come in. Then you've got nuisance. I just got a judgment today on a nuisance case. Wasn't a land trust one, but that's a big part of it. Nuisance is basically if you're unreasonably using your property and interfering with another. So if someone has diverted water onto your property, that could be considered a nuisance as well as a trespass. And civil theft is one that most people don't think about, but you have criminal theft, which is I stole something and the police arrest you and put you in prison potentially. Civil theft is where you take something that's not yours, and there's a civil statute that says you can get up to 3 times the value of the thing that they stole. So if they take your trees, in addition to other statutory provisions, you can actually get triple your damages if for some reason the statute doesn't work. Now, the reason why you're a little bit different than other places is that there's a special statute that applies to land trusts. It's called the encroachment statute, or at least that's what I call it. It's 52560A. And that statute is the only statute I know of that references a particular book as the standard by which you measure damages. And what it does is this statute says that anyone who encroaches or enters the land of a municipality or a land-holding nonprofit organization and damages that land, either the land itself or the vegetation on it. So that means if they're like digging trenches, that also counts. That they have to pay the full restoration value and up to 5 times the damages. There is no other statute that has quintuple damages in it. And those numbers like I said, the base values of these things can go hundreds of thousands. And if you multiply that by 5, it gets to be serious money. So it's the beauty of the statute is that it's got a huge deterrent effect. And while that may not be something you need to know from a legal standpoint, but from a leveraging standpoint, you have a lot of leverage against somebody who encroaches on you, because if you send them a copy of the statute and you tell them you could be up for 5 times the damages suddenly, and attorney's fees, they start to take notice, because that's a significant difference than most people's perception. The old perception was, if I cut down a few trees, I'm only going to have to pay for the value of replacing those trees. And oftentimes that was, get some nursery stock, throw it in the ground, 1-inch stock maybe, or even sapling stock in a 1-gallon bucket from, the local horticultural center. And you're talking about, $300, $500. And so it was economic for people to make the conscious decision to go in and cut trees or cut vegetation to get a view, which is exactly what happened recently down in Greenwich. They were trying to get a view to a pond down in Greenwich. That's a classic encroachment. And so they made they would often make those decisions because the penalty was far less than the value they got back. Because if you get a view to Long Island Sound or a pond or a ridge line or a scenic vista, that can increase the value of a property by hundreds of thousands of dollars. And so it was an easy calculus to do. So this guide to plan appraisal is the book that the statute refers to. And while you don't have to have it, it's about a $90 book, but it's a book that your arborist should have. If you're working with an arborist to help you with encroachments, you really need to have them be familiar with the book, because this book sets forth a very specific procedure for valuing cut down trees and vegetation by species, health, age, canopy size, diameter at breast height, a whole bunch of factors. And then they've got a whole calculus in a workbook that you simply fill out the charts and do the multiplication, and you come up with a number. And the numbers are astronomically higher than you might anticipate. You might think, oh yeah, we can go in and we can restore this with a few trees and some mulch, and my landscaper would do that for $5,000. The first case I did was 14 trees, and the numbers came out to like $180,000. Now these were large hardwoods. They were, I think there was some black walnut in there, but the numbers under the calculations for the guide to plan appraisal are very high. And the reason for that is it takes into account something that was never taken into account before, which is the lost ecological services value of the trees. Now, trees, of course, perform habitat functions, shade, they cool areas, they provide evapotranspiration, water management, they keep rainfall from hitting the ground too hard, they perform a lot of ecological services. This book actually takes all of that into account, and if you're replacing it with nursery stock, it will take, let's say, an 80 or 100-year-old tree, a 28-inch diameter, something like that, 20 to 25 years in some cases to reach structural parity. Structural parity being the same general size and canopy of the tree that was taken down. And then from there on, it matures and does other things over its lifetime. But that's sort of the, for your general red oak or white oak, that's the the time frame. So it's a really important thing to keep in mind that you have this thing behind you in this concept that you're not just doing a traditional restoration where, hey, we're going to throw in some seed mix and we're going to throw in some plants. You're actually going to do a restoration that that gets you back to either structural or ecological parity. I probably went a little long on that. Okay, so now one of the things, here's an action item for you guys, and you may already do this, and so please, don't mind that I may have sort of given you something you already know here, but one of the most important things you can do is get a baseline report. You need to go out, and when you acquire property, and even if you've got property that hasn't been done, observed and monitored, you need to go out and get a baseline report. And that is basically a report of the condition of the property as it exists at the time of the inspection. That way, if someone comes in and does something to it, they damage the property in some way, whether they're dumping on it, they're moving a stone wall, they're taking down a tree or some vegetation, or they're creating a trail, you've got photographic documentation in a report that you can pull out and say, as of January 2024, this is what the property looked like. This is what it looks like now. This is the difference between the two, is what you caused, encroacher. Without that, there's often the casual defense of, hey, well, I didn't do all of that. And how do you know? I mean, sometimes it's obvious, but a lot of times it's not. So a baseline report is really important for certainly every piece of property that you acquire going forward. And then to the extent you can go back and go to your old properties and sort of backfill on the properties that don't have, baselines, you should probably go and do that. Now, you don't need a professional to do it, although many land trusts will. And they'll have a forester or a natural resources consultant of some sort, document the species and the health, excuse me, and the general lay of the land from a more ecologically scientific point of view. But something, if you've just got photographs and a general description, that's going to be a heck of a lot better than nothing. And so don't be deterred simply because you think, oh, we don't have the expertise to do that, or we don't want to hire it, or we don't have the budget for that. You can do it yourself. Smartphones are ubiquitous and easy to take photographs with. And And you don't need that many, but you do, you'll do yourself a real lot of good with that. Now, in here, I say enlist neighborhood support to report problems. One of the things you should do is, a lot of your properties are going to be surrounded by neighboring properties that are occupied by people. You as a land trust don't occupy any of your lands. And so you rely on them to be your eyes and ears. And so you should occasionally, periodically, because, houses change hands, send a friendly note saying, hey, we're your neighbor. We own that property on the end of the street that's open space. We're the Trap Rock Ridge Conservancy. And that property enhances your values. And we rely on you as our eyes and ears to tell us when something's not quite right. If you see people doing damage, lighting fires, cutting things, whatever, please let us know as soon as you can, because that helps us protect the land that's been protected for your benefit. I will tell you that that friendly letter goes a long way to establishing that friendship. And they will be helpful at some point. If you decide, or excuse me, if you discover an encroachment and you want to go and do an investigation of that, going to the neighbors and asking them, what they know, if they've already sort of been enlisted to do that, they won't be surprised when you come knocking, and they'll know who you are. And that's also an opportunity for you to give a little brochure about your land trust and say, hey, here's who we are. Maybe you'll get some donors out of that, some supporters, maybe some volunteers. So you should also develop written policies and procedures for responding to potential encroachments. I don't know if you are a certified or accredited land trust, but if you are, I know the LTA requires you to have a number of procedures put in place, and you also need to have the baselines and all that. But even if you don't, you should develop some sort of process that you follow so that, you guys might be knowledgeable right now, but the people who come in after you on the new board, your new volunteers, they can look at your policies and procedures and know what to do in case they're the one on call when the telephone call comes in saying, hey, somebody did something over at the whatever property. And those policies should basically say, who's going to do what when, because you don't want to have there be a lot of confusion. You do want to move quickly when you discover an encroachment. So then I have this thing that I call the measured response. Not something I probably made up, but it's, obviously you don't, like I said in the beginning, you don't go to court first. That's the last step in the process. The first thing you do is, in a lot of these small towns, somebody in your group knows the person on the other side, the person who encroached either on your easement or your land. And if you can go and talk to them and say, hey, did you know that you can't dump here? Or we noticed that you cut down some trees. Let's talk about how we can resolve that. Person-to-person communication, can go a long way. A lot of times, if it's a really serious encroachment, they know darn right well what they did. They did it on purpose. And you're probably not going to get a great response. You'll get a lot of excuses. In that case, then you write to them. You have someone from the board, whether it's your stewardship manager or your president, write a letter that says, hey, we noticed that there's been this encroachment, and it involves approximately so many trees and some damages, and we saw the wood in your backyard. So we'd like to talk to you about resolving this. Is fairly serious. You've trespassed, and see if they respond. You give them a period of time, usually 10 days to respond. They don't respond in 10 days. They're probably not going to. And then sometimes you skip right over that one to the attorney letter. You have an attorney write them a letter if it's a serious encroachment. That catches their attention because they know that, look, you're serious enough to have gotten counsel involved. It's not that expensive because it's just a letter. And I'm usually working off of not quite a form, but a format that I've used before. And so I'll modify it to the particular instances. And if you have another attorney, you simply ask them to do that, customize a letter for you that says, hey, make sure that you let them know that we know what we're talking about. You describe the encroachment, you tell them that there's penalties, you have them write in the 52-560A statute and the quintuple damages and attorney's fees. So you let them know that, we're serious, and you enclose a copy of the encroachment statute with the letter, because if they turn it over to their attorney or discuss it, the attorney will know what that means and will probably advise them to do something either responsible, or if they're recalcitrant, you'll know right away. They'll either, tell you to go pound sand or just clam up, in which case then you might have to go to this last step, which is asking your attorney to do an enforcement. And that's when, your response to this thing is going to matter. And so here's my sort of little diagram about what you do when there's an encroachment, which is the middle circle here. The top thing is get your ease. If it is an easement property or it's a deed restricted property, get the document, because that easements vary, and the difference between one easement and another can be miles apart, and it will control what this person can and can't do. And it may well be that whatever they did, they were allowed to do. So the first step you want to do is get your easement and read it. And if it seems a little too legalistic, have your lawyer interpret it for you. Go get your baseline study. You should have had it done so you can take a look and say, okay, what did they do? And what was it like? Oh, now we know what was really happening here. Now, oftentimes when you look at the damage, you can tell whether it's new or not, because the cuts will look fresh. There'll be fresh tire tracks. There'll be fresh breaks on branches and things. Or you'll see that the wood has turned gray and it's weathered a bit, or things have rotted down or tamped down. So you can get a relative view of when things happen. Interviews. Interviews are really, that's, like I said, you enlist your neighbors to be your eyes and ears. Talk to people who are neighboring and see if they saw anything, heard anything. You don't have to record it, but just write down a few notes about what they know. If they're a witness, that helps your lawyer. But it also helps the next step, which is if it's a serious encroachment and you're not getting any cooperation, if you turn it into the police, at least then you have a governmental document that says, we went out there, we looked, we investigated. Plus, the police also have the ability to go into other properties and look. So you don't have the ability to do that. That would be trespass on your part. So you don't want to go walking on the neighbor's property, even if you think they've got your trees, or your soil or your rock that they've taken off. So you'll ask the police, and if the police go out and inspect, they will often take pictures. And if you ask them to do so, that'll be more likely to happen. One of the things that you want to put in your notes is figure out what species were lost, how many trees were cut. Now you may need the help of an arborist. Not necessarily. I mean, probably many of you are knowledgeable about generally which trees are growing on your properties. And many of the common species are easy to identify, especially if the top of the tree is still there. You can see the leaves. But oftentimes the wood has been taken and all you'll have is a stump. And even for experienced arborists, it's difficult to tell the species from just a stump. Sometimes you can tell from the bark. Sometimes you can tell from the wood. Sometimes you can tell from other leaf litter and things that are, like there's acorns all over here. It must be an oak, that kind of thing. Photographs. Photographs are cheap. They're not film cameras anymore. You can take lots of photographs, and taking a photograph of every stump and all of the slash and things that have come down, because that stuff moves. People will often take the wood because it's valuable or because it's evidence. The last thing I was talking about was the letter that you send. And actually, I put here certified letter. You don't actually have to use a certified letter. You can send it by regular mail. Let me tell you, if they don't respond, it's not because they didn't get the letter.
Keith, can I interrupt you for a sec?
Absolutely.
Can we go back one slide?
Oh yeah, now I can.
Oh, never mind. The first thing when you talked about measured response. Yes, thank you. The first one, talk. So I'm not sure I feel comfortable walking up and knocking on somebody's door and saying, "Hi, I'm from the Sharp Rock Ridge Land Conservancy. Did you know that you have built your shed on our property and cut down our trees? And are you aware of that?" I'm not sure I feel safe doing that.
Okay, so that's a very common concern that I get when I mention this. Talking can also be by telephone.
Okay.
My point is that, and remember, I said many of your people on your board or your volunteers may know the person involved and have a relationship with them already, and can say, "Hey, Joe, Jane, I want to talk to you. The land trust told me that you guys cut some stuff." that personal touch can often diffuse a lot of things, but you're right. A lot of the people who do this kind of stuff are knuckleheads. They're mean-spirited, ornery. They be of any species of human. And I'm being a little tongue-in-cheek there. I mean, but they can be rather offensive people who are not going to be conducive to having a civilized conversation with. Sometimes you'll know that in advance. Sometimes you just don't.
Okay.
Skipping the part of making that personal contact may be a wise idea. In fact, most of my clients do that, although about a third of the time they've said, oh, yeah, we talked to him and we didn't get very far, or we talked to him and whatever. But most of the time I'll get exactly the same thing you said, which is, I'm not really comfortable. The guy's a little, he's a little irascible, and he's been talked to by the police a few times on other matters. So yeah, you have to use your best judgment on that one.
My preference would be just to send a letter, but I guess maybe that's not the best. If nobody knows this person, they moved in 2 years ago and they started cutting down trees and piling up wood. And then they built a shed on our property and put a fence around it so we couldn't even walk our boundaries. Then chances are, my tendency would be to send them a letter with a map.
Yeah, and actually, look, there's nothing about this that is required by law, nor is it required as a matter of proof. The court doesn't expect it. It's just my way of saying you use the lowest confrontational method possible, but if it's not appropriate, going directly to a letter is what most land trusts do. Because a letter, one, is documentation. It puts a flag on it. It says, as of this date, we informed you of this. And so you have a little piece of proof that says, we tried. And if if your enforcement folks on your land trust are uncomfortable with even the telephone call approach, go right to writing a letter, because the letter it doesn't have to be accusatory and nasty. In fact, you don't want it to be. You want it to be matter of fact and businesslike. You want it to be firm, saying, look, we observed this on our property, and we have reason to believe that this was your activity. I mean, your property surrounds it, or, there's a trail going from your backyard and there are tire tracks, or whatever. I mean, if you're not sure who it is, then obviously be careful about who you accuse of what. There are times when you will have an encroachment where you won't be able to tell who it was. I had a couple of those early on, and it was frustrating because, if you can't identify who it is, you can't get them to, make good on it. But many times you can, especially because when it's a direct abutting neighbor, usually those are the ones who encroach because they're trying to expand their lawn. They're trying to put in a structure. They don't know where their boundaries are, and they just cross it when they're clearing to get a better, more airspace in their backyard. Oftentimes they do it intentionally. They know darn well where their boundaries are. I had one where it was an environmental lawyer and his wife, who was also an environmental lawyer, and they crossed into the land trust property and cut down those 81 trees. Both of them knew what their boundaries were. I mean, they said they didn't, but, credibility is a thing. Anyway.
Okay. Well, thank you for that. Thank you.
So here's an actual photograph from one of my actually. And you'll see I took pictures of the stump. Now, this is just a general scene setting shot to show what the scene looked like. But what you really want is this kind of photograph. You want to get right up close and personal and show the stump. Nope. And I'm going to pause here for a second. My internet was telling me it was unstable. All right. So what you want to do is get a nice up close and personal shot like this, because until your arborist gets involved, things may change. And so the faster you can get some good close-up stump shots. Now here you can see the bark. I think you could almost tell. I'm not sure if that's a red oak, but you can see the bark. You can see the size of the tree and the rings. Oftentimes I will take these pictures with a ruler or with a glove. When I was out in the woods, I didn't have a ruler. I just threw a glove on top of it, and that gave scale. And then if I could find that glove again, I can actually get the measurements off of it. If you don't happen to have something to measure with. But if you can provide this information to your investigating arborist, that will help them, because even if they come in after the fact, they'll probably be able to find the stumps, because people don't usually stump the fields, but they may take away the slash, the canopy, and the trunks. Now, while this isn't at breast height, a good arborist should be able to tell you that at breast height, the diameter will probably be very similar to this. If you're at the root flare, it will be a little wider. But... Oh, did I hear someone? Okay, I'll move on. So also using the GIS data, in most of your towns, you have the assessor's maps, and which are not terribly accurate. They're only good for sort of getting a general idea of where things are. You're going to want to find out where your boundaries are. In fact, if your property hasn't got a proper survey and you don't really know where your boundaries are, one of the things you might want to do, because a lot of encroachments are just across the border by 10 feet, by 15 feet. And that still could be a serious encroachment because they can cut a lot of trees within that space if it's wide. You'll want to maybe get a surveyor out. You don't have to do an entire survey, but just do a line survey where they just shoot the line and put in some stakes. And that'll tell you, yep, they're over the line. Take some photographs of those stakes because wooden stakes move. They're remarkably mobile. When people tend to find out that that's what you're doing, they know that you're documenting what they did. So in this case, what we did is we actually, if you look in the middle of this thing, you'll see some little dots here. Those are actually tree symbols. And we actually GIS'd with an app on the cell phone, and we geolocated all of the trees, so we knew exactly where they were on the map, and then we could impose the map over it, and then we could prove that where they were on our property. That would be later for evidence, but it would also be good for negotiating the settlement. Here I've got we labeled all the neighboring properties. In this case, it was one of the neighbors, and we knew that because we saw the wood that looked remarkably similar to those trees that were cut in their driveway, all fresh. And one of the other neighbors actually, luckily, heard the activity and actually kind of identified it for us. Okay, so there are other databases that you can use. Yukon's Clear and Connecticut Eco are websites maintained by Yukon, and they have aerial photographs and online maps that have incredibly large amounts of data. Now, if you haven't used it before, it can be a little intimidating because it's a little bit technical. But if somebody in your group can get facile with it, then they can find aerial photographs going back to 1932. 32, 51, 54, I think all through the 70s and the 80s and the 90s. And they even have color and false color photographs, which tell you what kind of vegetation was there. But the aerial photographs are remarkable. They were taken by flyovers with military grade cameras. And so you'll see this massive area, which covers like 3 towns. And you can zoom in on these things right down and you can see individual cars. So they're good maps. And here's an example. Here's what it looks like when you get one of these maps online. And you're obviously looking at literally the 30,000 foot level. You can zoom in on these because of the acuity on these. You can go right down to an individual car and even see shadows on trees or what was left. And this is, I think that's a zoomed in version of that same, yeah. Okay, let me go back. So this is a photograph in 1934. This is the same area in 1951. And what you'll see is that there's a lot more development, and you'll see it over time. So you can actually get a lot of the history of your properties this way. I don't want to dwell on this because this is maybe getting a little too specific. But the point is that there's lots of sources of information that you can get. There's topo maps, which will give you a lot of information. There's GIS maps, there's field surveys, there's data that you can get in the field. These guys in this photograph are using GIS, mapping tools. But there's historical maps, there's assessors maps, there's maps at the town clerks. Obviously, I talked about photos and videos. There's the geologic maps. I mean, so you can get a lot of information. There are also satellite images that you can buy. That's probably a little advanced. They cost a little bit more, actually a lot more. And but you can get satellite images from the spy satellites that became declassified, and you will get high resolution, false color photographs where you can actually look at the vegetation. Here's actually, and you'll see this thing change over time if you'll watch it on the screen. And I'm going to go back and show it to you again. That area, see that area where the arrow was pointing at? These were these were satellite data photographs, and the false colors, the purples and the blues and the greens, can actually tell you how new that vegetation is, well, what its age is based on the reflectivity of it. So we'll go back and hold on. Okay, so this slide basically will change over time, and you'll see we got the later photograph, and it shows you that there's that new vegetation. You can also tell vegetation has been from pollution as well. Pretty interesting. So, this is, like I said, the advanced version of it, but the point is that you can get a lot of data that's, if you don't have baseline, you can recreate it. So I'll move on from that. Now, defenses and shields to liability. This is more really more for the lawyers, but I wanted to let you know that sometimes there are defenses to an encroachment that you might try to pursue. And the first is the easement language. As I said, if you've got an easement, that language is going to control, and what someone might have done might have been allowable because they have reserved rights. They have the right to cut logs for fire. They have the right to pick mushrooms or berries or hunt, or I do a lot of, or they maybe even have the right to build in certain building envelopes. So you can't just assume it's an encroachment with an easement. You have to look back to the easement itself. And then I have here, you need to have standing. If you aren't the owner, it becomes a little bit more difficult to enforce encroachments. So even if you're an easement holder, the easement will have enforcement provisions. If it's a modern easement, it'll have very strong enforcement provisions. If it's an old one, you may have difficulty enforcing it because the underlying landowner may or may not agree with you. So keep good relations with those owners. Now, the person who gave you the easement is probably a friend. That's why they put it into an easement, because they're a conservationist. But the people who buy after they pass the property on, whether they die or whether they just sell it and move on to Florida, the new owner may not know. And in fact, if you know that one of your properties has changed hands, you should send a friendly letter saying, hey, we're the land trust and we own an easement on your property and we wanted to let you know, here's a copy of it. We just want to let you know, we like to maintain a good relationship with our owners. We expect you to be our eyes and ears. So you start out very friendly with them. Don't assume they're hostile. Adverse possession. Here's an unfortunate policy. Land trusts are immune from adverse possession, which means people can capture your property if they fence it off and hold on to it for 15 years in a hostile and open fashion. Adverse possession is a statutory thing, and it does not run against land trusts. And land trusts have been given a special immunity from land trusts, from adverse possession. However, that statute went into place in 2002. Actually 2001, but it became effective in 2002. And so only since 2002, adverse possession has not run. And so occasionally you'll get an old property where the owner will say, I own that land. And you'll say, no, we've owned it since, 1990. Well, the problem is if they had 15 years where they occupied it prior to 2002, they can actually say that they own it. And so you want to be aware of that particular type of thing. But it only applies to adverse possession that occurred before 2002. It goes back to like 1985 or so. Those kinds of claims are getting fewer and further away.
If somebody, sorry, go ahead. If somebody put up a fence on our property in 1985 and we just discovered it last year, then they're right. That property is theirs, right?
Yeah, you might be out of luck. It
Okay.
depends on the circumstances.
Okay.
Because if they put that up with permission, like, if the land trust said, someone said, hey, I want to fence in my sheep. Can I just put my fence over here? And the land trust said, sure, that's with permission. That's not hostile. It has to be hostile.
Okay.
And if they don't have proof that it's hostile, you can claim that it was by permission. Of course, you'll probably need somebody to say that was the case. So adverse possession has to be hostile. It has to be something where they thought they didn't own it and they're trying to own it. If they had permission or they had a license, nope, they're out of it. This last thing is,
Can I ask you a quick question?
oh, absolutely.
For adverse possession, if there's a new homeowner, but the encroachment was from a former homeowner before 2002, could they use the previous owner's time as part of their adverse possession claim? Or would it start from the time that they own the property?
Nope, actually they can. It's called tacking. You can tack on to the previous owner's time. So if they had 7 years and you had 7 years, and then another year, another person had 1 year, that's 15. You can add them together. I've never seen it where the previous owner had all of it and the new owner had none of it, but I think they still could do that, because if they could get the evidence that the fence had been there for that period of time, let's say that they had records from the previous owner showing that the fence was bought in that time or whatever. I mean, sometimes it's really hard to prove, but aerial photographs will sometimes disprove that. And so the proof of adverse possession has to be clear and convincing. So they've got to come up with, some pretty convincing evidence that they captured it. But the short answer is yes, it can happen.
Okay. There's another question from Susan. Can I read it to you?
Yes, please.
In the chat. My homeowners association has a covenant with the town. Is that different from an easement? Who enforces it? The homeowner president is one of the offenders and gave permission to the other homeowners to throw yard trash on the conservation land.
Okay. Well, again, just like with an easement, it really depends on the language of that covenant. I mean, a covenant is just another language, another word for an easement. So it sounds an awful lot like a conservation easement, and it sounds like it probably was an open space set aside from a subdivision, which is very, very common. And if that's the case, usually those open space set asides are either given to a land trust, in which case the land trust would have the right to enforce it, or it was given to the municipality, in which case they have the right to enforce it. However, sometimes the municipalities then later transfer that to a land trust, or if a land trust says, hey, wait a minute, that's open space and you can't, and I mean, you guys are not generally general environmental organizations that enforce just randomly. If it's not your property and it's not your easement, you ought to think long and hard whether you want to become a private environmental enforcement organization. But if it meant something to you because it was adjacent to your property, or you had another interest in it, or it affected your property because they were ruining a pond that drained onto your property, or a stream that drained onto your property, into your pond, you might want to use the Environmental Protection Act, the Inland Wetlands and Watercourses Act, either of which you can use as a third party to enforce that. But the first place you'd go is find out what that covenant says. And most likely you're going to have to talk to the town and try to get them to do something if this is meaningful to you. So hope that answered that question.
Okay, I have one more question.
Go ahead.
Okay, so Susan was just asking, if it's not in a land trust, who can I call in the town? I assume they would call the zoning enforcer or the town planner?
I mean, probably the town planner would be at the top of the land use department usually. So the town planner would probably be the first stop. But if it's a wetland, you would call the WEO, which is the Wetlands Enforcement Officer. If it's not wetlands, or you don't think it is, you can call the ZEO, the Zoning Enforcement Officer. And the ZEO would probably be the one who would be the enforcement officer in charge of this kind of enforcement. And if you have a land use administrator, you could start there and then they would decide who wants to handle it, because every town's different in how they sort of administratively deal with it. Now, if you don't think that the staff is going to be terribly sympathetic, look, that's what your selectmen and your city council or town council exists for. I actually sat as a first selectman at one time. People came into my office for all sorts of things. And the reason why they did that was because they knew that I was politically responsible or responsive, and I would take it to the right person. So if you think that the staff might be, not interested, going to the top of the heap, the executive branch, and having a chat with them and saying, look, there's this thing that happened, you guys really should care about this. Could you help me or help us, get this done? Oftentimes that kind of an approach will help smooth the way, because certainly if it comes from the top, staff don't have a choice to bury it. And if you start out and you get a hostile response from staff and they go to their boss, then when you go to their boss to try to get them to do something, they'll say, oh yeah, you're just that crank who harassed my staff. So using the political channels that you have, because land trusts usually enjoy a fairly robust reputation with their host communities because you guys are politically neutral, you're doing good things, you're just generally non-controversial. And so play on that. That's a valuable thing that you've developed.
All right, I have another question for you.
Fire away.
On the subject of aerial maps, Google Maps are so detailed now, I can see the trellises on my tomato garden. Are Google Maps acceptable evidence to prove prior conditions and subsequent changes?
They actually are usable. They're a little difficult for attorneys to use. I mean, there's a way to do it because the underlying images, you have to go into the metadata that establishes their actual date. Because if you see Google image, 2024, that photograph may have been taken in 2023. And you can get the actual metadata behind it and prove that that image was taken at a certain time and who took it and be able to prove it that way. So don't rely on them just for face value, but they're really, really a super inexpensive, very easy way for you to get a check on what was there before. So, you want to do some amateur sleuthing, that's the easiest way. Everybody can pull it up on their computer. You can look and say, wow, that shed wasn't there, 3 years ago. And because if they start claiming, oh no, that shed's been there for 20 years, I own it. Nope. I've got this Google photograph and it's either 23, 24, or 22, but your shed wasn't there then. It also can help. You'd be surprised at how much information it captures. Sometimes you'll actually see the vehicles. Like if it was a project, you'll actually see what we call the yellow metal, the construction equipment with the front end loader digging up the logs or whatever, or I've actually seen actual cutting material going on. You can't tell who's operating it, and you can't tell the name on the side of the vehicle, but it certainly does establish that vehicle has tracks going on to the other property, that kind of thing, if you're lucky. So anyway, so this last one is kind of a tongue-in-cheek one. It's the SODDI. Some other dude did it. And basically what that means is if you haven't got proof, the person you're saying, hey, you encroached on my property is going to say, no, it wasn't me. Somebody else did that. And if you don't have the proof, then you're not going to be able to enforce. And so that is just a quick lesson in not every encroachment is enforceable. Sometimes you just have to clean up and move on and put better signage on your property, saying don't trespass here, or blocking off trails that come onto your property. Sometimes you can't prove it. But you should just be aware that that's why you do all this baseline and this sort of sleuthing to determine what happens. Hang on. Okay. So I was talking about the statute of limitations earlier, and I sort of covered this, I guess, which is you have 2 years to file a tort claim, which is an encroachment. Now that can be held in abeyance. It's called a continuing tort, which is if they're still doing something on your property, that's a continuing tort. That's a continuing trespass. If they dropped a tree onto your property, that's a continuing trespass. However, if they dropped one of your trees on your property and it doesn't touch their property, it's 2 years from the date that they did that statute runs. So the only way you can actually hold that statute of limitations of 2 years open is if they're continuing to do something or they've deposited something of theirs onto your property and it's still there. As long as their stuff is still in your property, that's still a trespass. And so, but you don't want to play amateur lawyer if you're not, and try to decide that you've got time to spare. The sooner you can get it to a lawyer to analyze it, this lawyer may be able to tell you, oh no, you got plenty of time. The lawyer may tell you, you've only got 2 weeks to do something. So even though you hold property in perpetuity, is obviously a very long time. As a practical matter, by the way, perpetuity only means as long as the United States is still the United States. If we ever lose World War III and somebody else takes over, I guarantee you, space isn't going to be held as open space. And that's not a political statement. That's just a reality. So that perpetuity is a aspirational concept. All right. So tree liability. I put this in here because it's a very common topic. And actually, by the way, what time or do we have on this? I know 8.
You mean how much time do we have to talk?
Yeah. I
I mean, I don't have a limit on it. I'm sure maybe another half hour and then people probably
will
would like to
tire of
wrap
hearing
up
from.
then. Yeah, hour and a half, I think is probably good, right? So
Okay,
if that's good with
I'm
you.
willing to stay. Yeah, I'm willing to stay as long as you need, but I just wanted to know if we were running up against some sort of deadline. So I've got the tree liability. This is it's kind of it's a pseudo encroachment issue because usually it's your tree encroaching on their property and the other party wants you to cut the tree because oftentimes land trusts are the ones that own the open space next to the open space set aside in the subdivision. So your neighbors are all homeowners who are maintaining their house and you're the one with all the trees. Now they may have trees as well, but their trees usually are maintained and cut and trimmed and fluffed and fertilized and all that. And sometimes their tree will fall on your property, but you don't care because it's just a tree falling on open space. And that's habitat and fertilizer and the squirrels love to run up and down them. But when your tree falls on their property, they consider it a gross violation of their private property rights. And they say, you've got to come and chop that up and you've got to do right by us. Well, the law says no way, no how. For 300 years, the case has been that if somebody's tree falls on somebody else's property, it's the person on whose property the tree fell who has a responsibility to clean it up. I know that feels totally counterintuitive, but the legislature has tried 7 times to change that law and failed. And the courts have actually cited that and said, because the legislature is reluctant to change that law, the courts are powerless to do so. Now, could that law change? It certainly could, but right now, the rule is if your land trust tree falls on somebody's property, and they want you to clean it up or they want you to fix the damage, it crushed their car or crushed their house. Actually, by the way, this AI generated photograph where I asked it to show a tree falling on a neighbor's Tesla. And that's what it gave me. And so if you hit someone's Tesla and they get all upset about that, you can actually tell them, no. Now, you don't have to. If you want to maintain good relations with your neighbor, a number of my land trust clients will actually do something where they'll say, look, we'll let you, drag it across and put it on our property. We'll send out our volunteers and we'll help you clean it up. You only do that if you want to maintain sort of good relations and it's the right thing to do, but you're not legally responsible for it. It's their homeowner's insurance that should pay for the car or pay for the garage or their house, or if it just falls in their yard, their homeowners won't cover, but you don't have to do anything about that if you don't want to. If you want to do it as a matter of diplomatic relations, you can. It's nothing that prevents you from working that out. But remember that that's the rule. Okay. So there's a couple of cases where a couple of courts have said, well, wait a minute. If it's in urban or suburban areas where it's really considered common for people to occupy their property and to know what's going on in their property, let's say you only own a quarter of an acre or half an acre, it's probably assumed that you pretty much know the condition of everything that's on it because it's not that big. Land trusts, however, own a lot of like 20 acre, 50 acre, 100 acre plus properties, and they're not occupied. You don't live there, so you're not expected to know what the condition is of your property. So these cases that say, hey, in this case, there were signs of decay and all that, those happened in situations where it was an urban environment. But it's a symbol that some of the judges are thinking along those lines. And it's not the majority law in this state. And frankly, these 2 cases were lost because the lawyers didn't really know, what the deal was. So I have what I call Tales from the Listserv. If you're not aware of the CLCC listserv that's hosted by UConn, you should sign up for it. It's not a lot of spam. You don't get a lot of frequent posts, but the posts there are there are a lot of land trusts, wetlands enforcement officers, arborists, and all sorts of professionals. I mean, water professionals. There's a lot of people who are fairly knowledgeable just from experience and from education and training, who will comment on questions posed. And it's a good sort of training area if you want to learn a little bit more. There may not be a post for 3 weeks or for a month, but then you might see 2 in a couple of weeks. So, but these tales are things that happen. So here's one, what I call land trust owner with a chainsaw. This is so common. These are the kinds of cases that come to me. You get a new owner, and since the pandemic, when we had an influx of a lot of people coming into Connecticut, snapping up properties to get out of the cities, and they came here with a really different ethic, and a lot of them cut a lot of land trust properties, especially toward the western side of the state. But I'm sure you may have felt the same effect, perhaps coming from the other side. But and here, the neighbor cleared an entire half an acre. It was 617 trees and shrubs, not just trees. And the land trust hired a forester who estimated the restoration at, somewhere between 400 and 40,000. The land trust hired another forester arborist who estimated only 59 to 65. I'm not sure why they got the second opinion, but once they did the second opinion, that became the ceiling, not the floor. So it really depends on, it matters who you hire to do your assessment under the guide to plant appraisal. Because people don't know how to use it, will do the traditional, hey, I'll throw in some stock and make it work. And it's really cheap. Whereas if you use the book the proper way, you'll come out with hundreds of thousands of dollars more. But that was where they sort of cut their own legs out from under them. The encroacher used a different tree book, the Perron's Tree Maintenance 7th edition, which is a forester's book from Tennessee. And that's often what the foresters will use because it comes out with much lower property damage values, and it's also limited to no more than 15% of the property value, the underlying property value. And with open space, that can come up pretty low. So the lesson here is you should always use the guide to plan appraisal because and make sure that somebody knows how to use it because the numbers are significant. Another neighbor moves in with a chainsaw. They cut down another half acre, but it was 68 trees. And their excuse, of course, was, oh, I thought we had, permission to do that. Land Trust hired an arborist who estimated at 375, and they used the guide to plan appraisal. And the case ultimately settled for 125. That's a pretty substantial settlement. That was to avoid going to trial, avoid having to do the expense of it, and it settled out with the insurance company paying that money. Here's an encroachment, and you'll see these stakes are the property stakes where it says no trespassing, and the truck is, 25 feet past the no trespassing sign onto the land trust's property. And this is actually this is the value of a good photograph. Here you've got a cutter chopping up the trees, shredding them and putting them into a truck as wood chips, because the whole place looked like a moonscape after this was done. And that's how, a day or so fast that evidence can be destroyed. And so if you see something going on, even if you're wrong, snapping a photograph of it, it can be very, very valuable. In this case, it was worth $100,000. Okay, so our third case is another neighbor moving in. This was 81 trees. They cleared 3/4 of an acre. And the estimate for the restoration was $232,000. And that one settled, I think, north of 100. And then this next case, number 4 here, and sort of lower down, this was the latest one, that one with the mountain laurels. And our estimate was $608,000 because mountain laurels are one of the slowest growing tree next to yellow birch, I believe. And because it would take so long to get to ecological parity or structural parity in this case, the numbers were very high. And that's before the 5 times multiplier. And that case just settled for $300,000. So the land trust is going to have a big chunk of money to be able to restore that land and perhaps maybe buy some other land. And so the lesson is make sure you use the formula. And make sure you get photographed. This is another lane trust encroachment, and you could see the tops of the trees and the slash and the trunks. This landowner actually claimed that it blew down in a storm, and a nice graph it shows it was actually cut, not broken. And so again, photographs, they're very important. All right, so this slide is, if we got this far and nobody was asking me questions, this is recreational use immunity, which is that if you open your land up for recreational use without charging a fee, you have immunity for liability. It doesn't apply to municipalities, but you can allow, and you'll see all the uses at the bottom of this picture: hunting, fishing, swimming, boating, camping, hiking, pleasure driving, nature study, water skiing, sport parachuting, hot air ballooning, bicycling. You can allow all of those things and not be liable if someone gets hurt if you don't charge a fee, so long as you don't have anything that you created that was a hazard. So if you dig a big pit and it's open and someone falls into it, no, you don't have your immunity for that. So you can make a trail, and that's okay, but don't make a trail along the side of a cliff, and you'll be fine. So that's just a little tidbit on the side. So I'm going to stop here for a moment and just sort of recap a little bit about, or sort of what the whole point of this exercise is with encroachments. You're stewards for these lands. You have to be active, and it does take some work, but once you get those baselines in place, walk your boundaries once a year, or having some volunteer do that for you just to check on whether something's changed is really kind of easy, or relatively easy. Now, even for a large property, now if the property is really huge and it's hard to access because it's on a steep slope or something, you can do it with a drone. You can do it with aerial photographs. It's not ideal because aerial photographs don't always show what happened under the canopy. But, getting someone out on land at least every year and a half, year and 3/4 at the latest, is really my recommendation, because you'll catch things close enough to the act that might have encroached. Now, if you've got things like sheds and chicken coops and fences, those are often ones you can negotiate because they're movable. They're things that, don't have to be restored and replaced. You shut it off. Yeah, the grass will grow back soon enough on its own, even if you don't seed it. Fence can be pulled up. Temporary things like, or lawn furniture, or a fire pit, or, playscapes. Those things can all be negotiated off of the property.
I have two questions for you, Keith, when you're ready.
Sure, fire away.
So this is kind of related to what you're talking about. For multiple properties with multiple encroachments, where's the best place to start? Do you start with the minor issues or just go right for the major events?
Oh, I mean, if you're out there, it's not that hard. The difference between a minor issue and a major issue is, documenting them is the same. It's just it's photographs. Obviously, the major ones are the expensive things. They're the ones that do the most damage. They're the tree loss, the people who have dug. I had one guy who terraformed the piece of property. He actually dug into a hillside and made a garden and put in sidewalks and stuff in his backyard, next to his driveway. And he literally cut into the side. So I would start with, I don't know. I mean, the first one that you see, and just keep moving on. But, obviously, if it's things that can change, like the shed, if they move it, what do you care? That'd be nice if they moved it. You don't want them to move the trees, though, because you want that as evidence, at least until your arborist gets there. So I would start, if you're going to document things, with the stumps, the slash, the pictures of the leaves, if there are any, and a scene setting shot that tells you, hey, this is what it looked like in general, and then go close up and show the stumps. Now, a stump picture doesn't tell you where that stump is, so you might want to geolocate them on your phone. There are trail map apps on your phone that you can actually put waymarks, and so you could actually mark where those are. If you can frankly, even if you can do it on a piece of paper, you just sketch the property and you say, yeah, it's over here on this trail. Oftentimes they're in clusters because people don't usually cut one here and one there. So start at the beginning and go to the end.
All right, here's another question. My neighbor cut trees that I think were on the conservation covenant land that is between our properties, but he will not get a survey of his property. What can I do now?
All right, so you can't force someone to do something they don't want unless you go to court. So you can get a survey of, if it's a common boundary, you can survey the boundary and find out where your line is. And you'll know if they cut onto your property or the open space. If you ask them to do it, they're going to be awfully reluctant to, provide the evidence for their own demise. So that's where you start, is you ask, but almost every time you're not going to get a positive answer to that question. So if you're not sure where the boundary is, call the survey. Well, first of all, go to your GIS maps, go to your aerial photographs and your assessor's maps and get a general idea. If they're way over the boundary, you'll be able to tell. If it's close, within 10 feet, the assessor's maps may not be accurate enough. If you've got your own baseline map, if you've got your own survey, take a look at that. And GIS data, sometimes the town can be a little more accurate, but ultimately you may have to get a surveyor in there to shoot the line. So keep a good friend with a surveyor on your board. So any other questions?
That's all I have in the chat for now.
Okay, let me just keep going here and see if okay, that's the recreational use immunity. I've covered a lot of that. And then, yeah, actually that was my last slide, which is, stump the expert. This is what the AI thought of when I said, come up with a picture of stump the expert. And I have no idea what the pumpkins and the little blue weird mushroom things are, or cacti thing are, but this is what AIs do. They're crazy. So I'm open for questions. Otherwise, we've pretty much covered the basics, which is make sure you do your documentation when you get your property, go back in time and document your old ones, and make sure you inspect on a regular basis to make sure that you know what you've got. And then when you find something that you can attribute to somebody, pursue it. Don't be afraid to have that confrontation. I know land trusts generally are non-confrontational, but it really is your duty. Find somebody who, is maybe a little more, forthright to have that discussion, whether it be by a letter or by a discussion, or, or have the lawyer do it if you're concerned that it's serious enough to do that, and maybe you don't feel that they're going to respond to the land trust, or they haven't already. That's really the basics of land trust stewardship, is making sure you know what you have and what happened to it, and then taking action to protect it. A lot of these things work out. I will tell you, the vast majority of encroachments that come to me don't ever see the light of day in a courtroom. I may have to write a letter, or I may just be advising the land trust, and the land trust now gets they get some information about how to do it, or some direction, and they approach, the person, however, through whatever connection they have. And, it can work out. If the person says, oh my gosh, you caught me, and they know they're going to face the music, sometimes they make good on it. And, you're not required to enforce everything. If they're a couple inches over the line mowing their lawn, you don't have to, you're not required legally to enforce that. I think morally, when they go across the line and they start cutting trees and taking stone walls and things like that, I think you are obligated, even though you have the discretion not to. So, obviously those are all judgment calls. And of course, if you don't know who did it and you can't prove it, that may be the end of that story. And so what you'll end up doing is finding out where perhaps they entered your property, and maybe blocking that off. So vehicles can't get in, people can't come in with a chainsaw. And if you think that there's an area where people are entering and you don't know who they are, you can put up no trespassing signs, or open space signs with a no trespassing sign, so that people know that's not an official entry. And if you see a trail that's not authentic, or one that's sanctioned, you might want to, the people using it for mountain biking, which can be really destructive or something, or motorbikes, you can block those off. Just roll a couple of boulders or some really big tree trunks and, you know, and cut off their access. So there's a number of things you can do to, address these things short of taking the more serious action. But I think I probably run through the majority of what I wanted to cover, if there aren't any other questions.
I have two questions. I have someone asking if these slides are available. And if so, if you can send them to me, then, I can distribute them to whoever would like them. But I will also take this recording and I'll put it on the Trap Rock Ridge on our YouTube channel so people can watch it if they want to watch it. So
I'll try to remember if you send me an email, that'll remind me when I see it to attach the slides. I think the size of this presentation can be emailed. It may be pretty big though. The images on this one are very large. If it's over 13 or 15 megabytes, I may not be able to do that.
Okay. And then I have someone asking how to find a conservation-minded lawyer in West Hartford.
Well, there's a lot of ways that you can ask. I mean, you ask if you know a lawyer, you can ask. I mean, I certainly know the people who do this kind of work. And do I know somebody in West Hartford in particular? Off the top of my head, I can't say yes, but Hartford has a number of lawyers who are versed in certainly environmental law. Many of them are with larger firms because Hartford being Hartford it's the capital of the state, and a lot of the larger law firms are there. The larger law firms tend to have more of a defense industry oriented kind of side. There aren't a lot of people who do purely conservation work. I do about 95% of what I do is conservation law. In terms of litigators, there's Green and Gross down in Bridgeport. They do this kind of work. In Milford, there's Jacoby Capel and Case, or I think it may be Jacoby and Case now. Let's see who else does this. My good friends up at Kramer and Anderson in Litchfield and Danbury out that way. There's some guys there, but they do both sides of the fence. Dan Casagrande is sort of on the green side of things. Some of their other lawyers are more industry side. I think Brown, Painderis, and Scott might do some of this. So there's a few. And then down in New London area, can't remember their name now. The name escapes me, but there's a firm down that way. If you need a referral to somebody, I'd be happy to give you some names. By the way, don't feel geographically constrained. Lawyers in this state really, I know I'm a solo and I work all four corners. Most lawyers, because a lot is done remotely these days, and so much is done with electronically and computer wise, people really aren't geographically constrained, even though by tradition we tend to stay within a radius of our offices. But I've got cases currently in Danbury, Torrington, Hartford, New Britain. I've got them all over, and plenty of them in New Haven and along the shoreline. But so I wouldn't limit yourself.
Those are all the questions I have. Did anyone else have any questions? You're welcome to unmute yourself and ask if you have one.
I know it's getting a little late. You all probably have had busy days.
Let's have you.
Yeah, I think that's all the questions. Thank you, Keith, so much for going over all of this. This was a wealth of information, and good just to be reassured of what our rules and boundaries are and what we should be doing as land trust. So we really appreciate you doing this. Yeah,
and one final thought. Remember, look, you guys are, and I said this at the CLCC conference if you weren't there. Land trusts are exceptional. You're like every other landowner in that you have all the rights of every other landowner, but you've been given special rights. You've been given a nonprofit status. You've been given special statutes that exempt you from adverse possession. You've been given special enforcement statutes because society has recognized you as the keepers of things that are very important. And one, you should be proud of that. And two, feel good about that. But you should also feel confident in your ability to manage your resources. You have some of the most powerful tools available to you outside of the government itself to protect your boundaries and to protect your land. And I think a lot of land trusts can be shy because they tend to be, they want donors from every part of the political and socioeconomic spectrum. And so they tend to be really neutral, but you shouldn't translate that into so non-confrontational that you're not willing to protect your property. But I'll leave you with that thought. You guys are doing, good work, and you should feel confident in your ability to stand firm when you need to. Thank you very much. This has really been my privilege tonight.
Thank you so much, Keith.
Thank you, Keith.
Thanks very much.
All right, everybody.
And,
Have a lovely evening.
and I don't know. Will.
Thank you, Amanda and Kathy.